Buenos dias, and I want to first express my gratitude to Attorney General Torrez for refusing to let the federal government stand in the way of justice for survivors. Jeffrey Epstein told his victims, I have the banks, I have the government, you have no power. He wanted to silence them forever. He thought his wealth, his powerful connections, and the isolation of Zorro Ranch could shield him and his accomplices from accountability here in New Mexico. He was wrong. New Mexico will not look away. We will not allow our state to be a hiding place for abuse. In the face, however, of federal disdain for the victims and a Department of Justice at the federal level that is obstructing justice, our job is to help expose what happened in that secluded mansion. And we will not allow the United States Department of Justice to hide the records our Attorney General here in New Mexico needs to determine which laws were broken and who should be held accountable. This fight is actually personal, I think, for New Mexico and New Mexicans, but it's also about a larger story about what does justice mean, and what does justice mean for women who've been abused, for children who've been abused, women and children who've been raped and trafficked. I'm the chair of the Democratic Women's Caucus, and I have sat over and over again with the Epstein survivors and their families. I've listened to them as they've described their abuse, as they've described the trauma, as they've described their fight for justice. And they are the heroes in this moment that we are in of demanding accountability, this reckoning against the rich and powerful who think that they can get away with silencing women who've been abused. It was the Democratic Women's Caucus who helped force Congress to pass the original Epstein Files Transparency Act. We held listening sessions with survivors. We believed the women who'd been abused and traumatized by the rich and powerful. And now we are in this new time of reckoning where we will no longer let powerful men force women into silence. And the Epstein survivors and I were holding a vigil. The DWC was holding a vigil when we heard about the Senate approval. It happened in one day, right? Passed the House, passed the Senate. We were all very excited. But we knew it was not the end of the journey. And in fact, what we have seen is even with the passage of the Epstein Transparency Act, the Department of Justice under Trump has refused to release all the files. There are about 3 million files that have not been released. We also know that they have failed to abide by the Epstein Transparency Act. They've redacted important information, and then they have disclosed to the public the names and information about the victims. And if transparency is not transparency, then justice is not justice. But I am so proud of what we are doing in New Mexico. We have set up the Truth Commission, and separately and independently, we have a New Mexico Department of Justice and an Attorney General who is willing to do the hard and important work to find out whether crimes have occurred in New Mexico and who must be held liable. But you cannot do that if you don't have access to all of the information. And that is why I am a co-sponsor and leader, together with Thomas Massey and Ro Khanna in the House, of the Epstein Transparency Act #2, which actually would give our attorney generals in our states where these abuses have occurred, would give the survivors a right of action against the Department of Justice or anybody else who would choose to disobey the law. Because you have to have consequences. It's not a mere suggestion. And so I'm very proud that we have done this. We need to put the power back where it belongs, with survivors and with the investigators working to deliver justice, not Trump and his personal attorney, who is now turned into his personal attorney general, Blanche. With the blessing of Virginia Giuffre's family, I also introduced Virginia's law to extend the statute of limitations for victims of Epstein's crimes, because justice should not depend on the date on a calendar. And it should never depend on how powerful your abuser is. So at this time, I want to tell you that the Democratic caucus will not accept the status quo. We will not accept the injustice, because no administration is above the law. And I want to turn it over to Attorney General, who has not only taken an active investigation into this case, but I am thankful for the way in which he has fought for New Mexico's interest as this Trump administration has cut funding and has continued to violate our constitutional rights and our state's rights in New Mexico. Attorney General Torrez.
So first, I want to thank Congresswoman Leger Fernández for her continued leadership and engagement on this important issue. For those of you, many of you have been reporting on this agency's ongoing efforts to gain access to the complete and unredacted Epstein files. It's now more than 180 days since we first initiated contact with then Attorney General Bondi and the Deputy Attorney General Blanche, who has since been elevated and confirmed. One of the things that is important is for the people of New Mexico to recognize that even while we are engaged in this litigation, which I readily admit is unprecedented. I'm not only a state prosecutor, but a former federal prosecutor, and the types of requests that we've made to this department were the types of requests that were routinely honored by the United States Department of Justice and federal law enforcement. And so the Trump administration and Todd Blanche, in a stark departure from the historical practices of that agency, are stonewalling an active criminal investigation here in New Mexico. Nevertheless, I just had the opportunity to take the Congresswoman into the war room to meet with our prosecutors, to meet with our investigators, and I want to assure everyone that even while that civil action is underway in the District of Columbia, a team of prosecutors and investigators is hard at work here in New Mexico to evaluate evidence, contact any information, contact individuals and witnesses, survivors who have information that may yet result in a prosecutable case. Before I'm asked, when we open it up for Q&A, I cannot give you specific information about the status or the methods that we have undertaken in that regard, but I want you to know that we are not waiting for the resolution of our pending lawsuit against Todd Blanche, the United States Department of Justice. That said, I think the Congresswoman's leadership and the bipartisan commitment that's been evidenced by Representative Massey, Ro Khanna, and others really demonstrates that transparency and accountability for Jeffrey Epstein's conduct and those who were involved in, engaged in, or aware of what was going on in not only the Virgin Islands and New York, but specifically here in Zorro Ranch, is something that everyone wants to see done. It is a prerequisite for justice that we have all the facts, that we have all the information. To state again, and is outlined in our complaint against the Department of Justice, Zorro Ranch is referenced over 13,000 times in those files, and yet a good deal of the information that would be helpful and relevant to our investigators and prosecutors is redacted in full or in part. That is separate from the millions of records that are not even included in the publicly available documents. So, in other words, the 13,000 references to Zorro that we know about now is probably a substantial undercount if we had access to all of those records. This act, if it were passed into law, would give this agency clear legal authority to access the information without going through what we've gone through up to this point, which is the TUI process. That is the process that until now has worked well in terms of structuring information sharing between law enforcement agencies. But again, it is now been a tool for obstruction. And so Congress, under the leadership of the Congresswoman, has created a clear pathway to give us direct access. And if that access is subsequently denied, it creates a new cause of action that would give us direct access to the courtroom. In addition to some of the legal remedies that we are already undertaking, we would have the opportunity to bring all of this before a judge and get access and fundamentally get to the truth. Because this is something that is of paramount importance not only to the public, but most importantly to the survivors. And I would also like to sort of recognize and highlight the fact that the excuse that was given by the Justice Department was not only legally unsound and deficient, but it was insulting to the survivors. For those of you who haven't been paying close attention, one of the primary reasons that Todd Blanche and the Southern District of New York offered in not turning over that information was because they claimed to be preserving and protecting the privacy interests of the survivors. These are the same survivors that had their own personal and private information revealed by this department. And that's why survivors came out immediately after that justification was offered and called it laughable. There should be no mistake. Hiding behind and claiming to stand up for the rights of victims when all you're doing is stonewalling an ongoing criminal investigation is insulting to those survivors and disgraceful to the cause of justice. And so I applaud the Congresswoman's efforts, and I urge members of Congress to take this matter up, to have it up for a vote. I know that there was a lot that you had to go through to get a vote on the first Epstein Transparency Act, but I think there's a broad bipartisan commitment to seeing more transparency in this space. And so with that, again, I applaud the Congresswoman's efforts and leadership and would now stand for any questions that you may have.
All right, we're going to take questions in-house first and then online.
Yeah, Blake Trolley, KOB. Can you just explain in layman terms exactly what this legislation does?
So basically, the Department of Justice is required under law to release the Epstein files. They're required to redact only the names of the victims, of the survivors. They are not allowed to redact names because it would be embarrassing or politically inconvenient or any of these other reasons. They are required to release all of the files. They have failed to do so. So what this act says is, and something that, you know, in retrospect, you think when you pass a law, the Department of Justice is going to obey the law, right? But what we are seeing is the Department of Justice is flouting a law that applies to them that was passed by the House, the Senate, and signed into law by the President. So what the second, and that's why it's just called number 2, the Transparency Act number 2 is saying there can be you're both supposed to do that, and if you don't do that, there is a separate remedy, a private cause of action is what we call it. In other words, attorney generals or survivors can go to the court and demand that the court order the release, and the court can also order damages. So it's costing the attorney general money to force the Department of Justice to release records that they're supposed to release, which they would normally release in a criminal proceeding, as the attorney general said. This would be a normal release and sharing of information among jurisdictions. There's also a law that requires it. But we are now going to put another layer on that and say that you can then go into court, bring a separate action, and also receive damages if the Department of Justice continues to refuse to do what they're supposed to do.
One other important aspect of the proposal is that it would eliminate any smokescreen that the department has offered up to this point. So, for example, confidentiality provisions in federal law or privacy protections that are being offered, it makes it very clear that the department cannot invoke those without specific orders from the court that support those sorts of rulings. In other words, they can't do what they've done to us and say, you can't have any of these records because we're concerned about privacy and confidentiality. What it requires is that they strictly limit the application of the privacy and confidentiality laws to what the Congresswoman was describing, which is only that information which is clearly identified as relating to the privacy interests of survivors. So you can't use it to shield information about other individuals who may have been traveling with Mr. Epstein, information about financial institutions that may have been involved in this, people that are politically prominent or culturally prominent in some way. You can't use that as a blanket shield for non-disclosure.
Yeah, John Rapolo from KOAT. I have a couple of questions. I guess first, Raúl, you are embarking upon a criminal investigation into the network of Epstein ties here in New Mexico. I know you said earlier that you can't really talk much about your investigation, but the end result is you're looking to prosecute people who possibly aided Epstein and his activities or turned a blind eye to what was happening at Zoa Ranch. Is that accurate?
So we are focused primarily on individuals who are subject to our criminal laws for their actions as accessories, co-conspirators, or otherwise shared in the criminal intent of Jeffrey Epstein. And the difficult part, which we've talked about and alluded to in the past, is that this covers an extraordinarily lengthy period of time, and there has been a lapse of time in having all of the relevant information made available to state and local prosecutors. I will point out again, my predecessor had initiated a criminal investigation in 2019 and was specifically told and promised by the Southern District of New York that in exchange for standing down that investigation, that they would turn over those materials. That promise was not kept. And that it forms the core of not only our lawsuit, but it also highlights the extent to which we face new challenges, in part because we relied in good faith, and my predecessor, I think, relied in good faith on the assurances of federal law enforcement counterparts that they would continue to work with us. We have not set any limit whatsoever on any individual that may be subject to a criminal sanction in our state. Your question about turning a blind eye or maybe institutional failure, and I don't know if I'm characterizing that correctly, I think this is one of the things that maybe distinguishes the inquiry that's been undertaken, as I understand it, by the Truth Commission and what's been undertaken by this agency. This agency, our criminal investigators and prosecutors are looking for criminal evidence of criminal conduct that will result in a charge. There may have been, and probably are, instances of institutional failure, of people not dedicating enough resources, of people not looking closely enough at what was happening at the ranch for 20 or 30 years. A good deal of that conduct, while it may be shameful and disgraceful, it may not be criminal in nature. And so my prosecutors are focused on what is criminal in nature and what is provable in court with respect to specific individuals who are engaged in the conduct. I think, and I anticipate, that the Truth Commission's sort of broader institutional view will capture that institutional failure and offer in its report not only facts to support those conclusions and maybe recommendations of how these institutions can better be prepared to prevent something like that from happening again in the future. But it's important for people to understand the difference in perspective. I'm looking for individuals that I can still charge and prosecute in court. Theirs is a lens that's focused more, I think, on institutional failure.
Perpetrators, Ghislaine Maxwell is in jail. Epstein's dead. So who else, Raúl, can you charge for criminal charges?
Yeah.
With maybe people who have supplied women, young women, to Epstein? You get where I'm going here?
Sure, and so to sort of cut to the chase, I won't tell you what names of individuals are on a whiteboard in this agency, because that's not in the nature of how we conduct criminal investigations. But I want to assure you that we don't start an investigation like this by saying, oh, it's only 2 people. We start an investigation by saying, who could possibly be involved in any aspect of this in any way? And then we systematically evaluate evidence to ensure that no one is excluded from a full examination. And that's the way we do the work. But this is, again, part of the reason that we don't talk about it is that in talking about it, we actually impact the ability of our agents to gather the evidence they need to make a professional evaluation of the evidence. Yeah.
We've got time for about 2 more.
So I want to just, you're a little taller than me. I don't quite need the the governance step, but I think an important point to make, and what I have heard the Attorney General Torrez speak about, is they start looking at this in terms of the victims of a crime. And we look at it, and I look at it from the political perspective as representing this district. Soto Ranch is in my district, of the victims of a crime, and also the victims that may be able to pursue civil lawsuits as well. And so the Epstein Transparency Act #1 and #2 were intended to allow both criminal prosecutions to go forward, but also civil prosecutions to go forward. And more importantly, the third thing I think you're pointing out is for the American public to understand that this behavior went on and that we are no longer going to accept it or brush it under the rug. And so my bill goes to not just allowing state prosecutors, but allowing the victims and anybody who's been hurt by the failure to disclose to bring the lawsuit. And we also need to remember that when we have a federal government, Department of Justice, that's refusing to investigate, when we have worries about pardons, then it is more important than ever that states review what may be criminally prosecutable, is that a word? What may be, what they could do at the state level in terms of criminal prosecutions which stand under state law. Because the state of New Mexico has passed laws saying that you are not allowed to do this to children. You are not allowed to do some of what has been alleged to women. And so that's what's important, that this is about New Mexico's laws being violated and not about what may or may, unfortunately, may not have happened with regards to the federal Department of Justice doing its job.
I think we've got time for maybe 1 more.
Good morning. Thanks. Joshua Bowling with Source New Mexico. You've argued before, AG Torres, that the DOJ's refusal to turn over some of these files is impeding your criminal investigation. I was hoping you could speak a little bit to how and whether this new legislation could maybe move the needle in the right direction for you, and potentially other investigations that are going on, such as the Truth Commissions.
It's a great question. So right now, under the first Epstein Transparency Act, law enforcement agencies like ours were not specifically included. And I actually think there is a logical reason for why we wouldn't be. It's because up until the moment we were denied access, there really has not been any large examples or significant examples of federal law enforcement agencies refusing to turn over critical information to their state counterparts, particularly when they've already promised to do that. So we were not included in that as a group that was specifically covered. And because of that, we had to seek access to the records by going through what's known as the TUI process. The TUI process, or the regulations that are set forth by the United States Department of Justice, where when you comply with those records, the department makes a determination about whether and to what extent you're granted access. And it is their denial under the TUI regulations, which we believe are arbitrary and capricious, which has led us to file what's an action that's basically under the Administrative Procedures Act, the APA, okay? That is a novel approach, right, to challenge the denial of a TUI request. What the Congresswoman's legislation does is say, we don't have to go through the TUI request process with respect to the Epstein files. We don't have to go through those regulations. They have an affirmative obligation to provide records the minute we ask for it, and if they deny it, we have an independent cause of action, which means we have a separate legal argument aside from our APA claim to make to a federal court, and then the judge is not relying on, case law and precedent alone in evaluating the strength of an APA claim. They're actually looking at a law that's passed by Congress, and they can say, Congress has clearly stated its intention to give us that access, and that would, if it passed into law, would be a much stronger legal argument, and one that would be we would have a much higher chance of prevailing in, right? As it is right now, we're undertaking a novel legal action because we're in uncharted territory. And so what Congress is trying to do is both to create an affirmative obligation on the part of the Department of Justice and give us a clear legal remedy should they fail to meet that obligation.
If I may just follow up with that, just to clarify. So you're saying that this bill would actually stamp into law that the DOJ must turn over its investigative files related to Epstein to state investigators.
I would. That is the law right now. So it's not that we're stamping into law. What we are saying is, when the Department of Justice refuses to obey the law, we're going to see you in court, right? So that's the piece. Is normally the Department of Justice follows the law, but what we are seeing is they are not, and we need to give a pathway so that the states, attorney generals, and the survivors have a way to get into court quickly and to get a determination quickly. So that's I'd make that distinction on the way you said it. The law right now is you're supposed to turn it over. You're supposed to turn it over not just to the attorney general, to the entire public, to the American public.
All right,
Unredacted except for survivors, and they are not doing that. So they have failed over and over again. And I want to remind everybody, it was Todd Blanche who was leading this effort to respond when before, and now he has now been elevated to the attorney general. So we were in this problem. Remember, that law passed, Epstein transparency passed, basically overwhelmingly. There was one person who voted against it in the House, and so it is a bipartisan effort. And we were saying we need to continue to have bipartisan support to enforce the law.
All right, we've gone over time. I know there's a couple questions we didn't get to. Please feel free to see me afterwards. I want to thank the Congresswoman and the Attorney General for your time. Thank you all for coming.
Thank you.